Hi, I'm Alison Warner, founder of Evolve and Grow and author of Build and Grow. Welcome to the Evolve and Grow podcast show, where I share lots of useful tips and advice to tradespeople who are looking to move off the tools and grow a really successful business. So this morning on the Evolve and Grow podcast show, I'm delighted to be joined by James Sargeant, who is Associate Director and a solicitor at Quigg Golden. Now, they are specialists in construction and procurement law. James has been with them for 6 years. And I've invited James on today just to have a chat about some of the situations that companies can find themselves in. And we're just going to talk about best practice, really, of what you should have in place to best protect yourself. And if the worst should happen, should things go wrong, how can you best approach it? How Quigg Golden and I came to meet was through a client who found themselves, unfortunately, in a bit of a sticky situation, and they were fantastic at guiding them and helping them find the right solution. So welcome, James. Thank you very much for coming on. Do you want to just talk to me a little bit about your background and how you came to specialise in construction law?
Yeah, I wish I could tell you it was a plan I had my whole life, and I always wanted to be a solicitor. I always wanted to do construction law, but it was a bit of a fluke, really, if I'm honest. I left school at 18 or 19, having just done my A-levels, was a bit unsure, like a lot of 18, 19-year-olds, didn't know what I wanted to do with myself at all, and decided that I wanted to join the police. So I tried applying for the police for a year or two, and didn't get anywhere with it, basically. I didn't get through to interviews or anything. And by this point, a lot of my friends had gone to university and were in like their third years and were saying to me, go to uni, it's great, you'll have a great time. And I'd obviously go up and visit them and thought, yeah, I can do this for a few years. So I decided to do a law degree to help me get into the police. So I went to university, I did the law degree, and I graduated when I was 24. I thought, happy days, I can now apply for the police. But about 3 or 4 months after I finished university, I was playing football and I broke my hip. So I had to have a hip replacement, and I was only 24. So it was all a bit of a crazy few months. So I had a law degree. I could no longer join the police. And I thought, well, now what do I do? And I was offered a chance to work for a very specialist contractor in construction who do petrol forecourts, but they get into petrol tanks under the ground and reline them with resin to make them safe and stop them leaking. It's very, very niche. And I thought, well, I don't really know what I want to do, so I'll take a job there, and just literally fell into construction. And I worked there for a few years, and then Quigg Golden found me via a recruiter and said, you've got a law degree, you work in construction, we're a construction law firm, there's not many people that have construction experience with law degrees. Would you fancy being trained as a construction solicitor? And I said no, originally. Because I was happy, I was enjoying what I was doing, I liked being on site, etc. And then about a month later, I was on a site in Solihull in Birmingham, and it had rained continually for sort of 2 weeks. And I was stood on a site, and I thought, why did I say no to Quigg Golden? So I rang them back and said, okay, I've changed my mind, any chance? And they said yes. And that was 6 years ago. So they brought me on as a trainee, and they trained me up, and I've qualified as a solicitor since. And that's how I fell into being a construction lawyer. It was one sort of accident after the next, basically.
So really meant to be.
Yeah,
clearly.
I like to think so. Yeah. And looking back, I'm so glad that I took the job here now. I absolutely love being a construction lawyer. It's fantastic. So,
and I would imagine it's fairly unusual for somebody in your type of role to have that construction background?
Yes and no. A lot of the sort of big city firms have construction departments, and I would say 90% of their lawyers, they go to Oxford, Cambridge, they just want to be lawyers. Quigg Golden, we're more 50-50. Half the guys here originally started off as, the two guys that set up the firm, they were engineers back in the 80s, realised they didn't like being engineers, but they were good at the legal side of things. So they set up Quigg Golden.
That must give you an advantage, surely, to having...
It does, yeah. So we've got QSs, project managers, engineers, that we teach the legal side of things to. And then we've got other people that are lawyers that we have to try and teach the construction side of things to. And as a firm, we've come to realize it's easier to teach people from construction the legal side of things than it is to teach legal people the construction side of things. So yeah, so we're quite big on recruiting, QSs and people like that have a bit of legal experience and think I'd like to become a solicitor.
Okay, interesting.
Yeah.
And what is it that you love about it?
I like the clients. Firstly, construction attracts a lot of interesting characters, a lot of really nice people. No two clients are ever the same. No two projects are ever the same. And I've got a lot of good relationships with sort of, the decision makers and the local sort of construction companies to my office in Kent. And I've built up sort of good relationships with people over the years. I enjoyed the work. Like I say, no two sort of projects I get involved with are ever the same. No two disputes are ever the same. And I also enjoy that construction as an industry, there are so many opportunities in construction. There's so many jobs. Like I say, I don't know if I'm always going to want to be a solicitor. I might want to become an adjudicator one day. I've always thought of doing a QS degree. And conversely, like I was saying earlier, there's people in our firm that started off as QSs and have become lawyers. There's so many opportunities to sort of grow your career within construction. You're not pigeonholed, and that's why I really enjoy it. I'm a perfect example. In 8 years, I've gone from getting into petrol tanks in the ground to becoming a solicitor. And I don't think there's many industries that is possible in such a short space of time. And the other thing I like about it is, there are so many opportunities to grow your career, not just in the UK, but there's opportunities globally. If you want to work abroad, you can. I've been offered a job last year in Dubai. As a construction lawyer, I turned it down because I'm mad and I decided that I'd rather live in England. But that is why I love construction. There is so many opportunities to grow as a person and to grow your career. It's a great industry. I'm very happy I fell into it.
You say that because it's a theme that has actually come up quite a bit on recent podcasts, just that. And we've had lots of different people on, but that's the common theme that A, there's just so much opportunity, but B, it's the diversity of opportunity as well. So our construction clients, I would say, tend to turn over between 250,000 up to about 3 million. So the smaller end of the market. What sort of things would you say to those who are listening that fall into that bracket? What are some basic things that they should have in place to protect themselves?
The first and most obvious thing, which I'm still surprised at a lot of projects being done without them, is having a standard sort of set of terms and conditions or a contract, something in place that you can use for all your projects moving forwards, that you give out to your clients and to subcontractors if you use them down the way, so that there is something in writing to set out the agreement between the parties. The amount of projects we see up to sort of, house renovations for £1 million where it's all verbal, and then issues arise, there's disputes between the parties, and we ask for a copy of the contract, and everyone looks at us, a bit sheepishly, and they're like, "Oh, we never actually did a contract." It doesn't cost an arm and a leg if you go to a sort of Quigg Golden or another construction law firm for them to produce for you a set of terms and conditions stroke a contract that you can use on all your projects moving forwards. That would, we're not talking an 80, 100 page, big contract here. We're talking sort of 10, 15 pages that just sets out clearly what it is you're going to do, the price of the works, what happens if there's delay or variations, all the sort of things that lead to disputes. And if you have a contract in place, you are in such a better position when you come to someone like me and say, there's been an issue, there's been a problem, how do we resolve it? Because if there's nothing in writing, then it's, a lot of he said, she said, and it's just, the more grey areas and ambiguity there are, the more likely there are to be disputes.
And what do you see the most common disputes being set around?
The most common disputes we do all involve payment in one way or another. And often they are concerned with sort of change management with the project. So variations, the client originally wanted to install one kind of worktop, and somewhere along the way it's changed, and then they don't want to pay for it. That's one of the most common types of dispute we see, is value in variations. And then the other most common types of disputes are to do with projects going over the anticipated program. So, it should have taken a year, 2 years later, everybody's still on site. Who's to blame? How did this happen? Who's paying for the contractors, additional costs on site for that year? They make up the vast majority of the disputes that we're involved with.
And with that latter one, because these are exactly the same issues that we come across, unsurprisingly, with that latter one where a project is overran, what percentage of the time would you say that is down to the variations not being managed versus the contractors either underestimating how long it's going to take or not managing the productivity of their team?
Usually, it's not one or the other. Usually, it's a combination of both. The contractor normally is not blameless in the situation, although if I'm representing the contractor, I will try and get the message across that they are. But often they're not always blameless, but predominantly there are more good contractors out there than bad contractors, and it's very rare that I look at a project and think that is entirely the contractor's fault. They might not have helped the situation, but invariably it's things outside of their control, or it's the client being difficult. There's normally a bit of both, but I would say more often than not, it's not the contractor's fault usually that they find themselves in that situation where the project's gone on longer than anticipated. But sometimes it's neither party's fault. COVID is a massive example that has impacted every project I've dealt with for the last 2-3 years in one way or another. Has involved COVID delaying the project, whether the site was shut or not being able to get materials, etc. And the latest example is the war in Ukraine. I've got clients that manufacture cladding abroad in a factory in the Czech Republic, but a lot of the guys that work there are Ukrainian, and overnight they were all heading home to join the war effort. It's so that's neither party's fault, and it's about making sure that when things are going wrong on projects, you don't bury your head in the sand. Be upfront and discuss it with the client from the outset. A lot of formal construction contracts, like standard form ones like JCT and NEC contracts, actually encourage or require the contractor to notify the client as soon as possible. Under NEC contracts, they're called early warning notices, and you have to notify the client, this has happened, there's been a flood or there's been adverse weather, and it's likely to impact the program. And it then encourages the parties to, work together to find a solution, as opposed to burying your head in the sand and thinking, oh, it will improve. And then before you know it, you're in a dispute with the client who was hoping to move into their new renovated house, 6 months ago, and they haven't. And it could have been avoided if you were honest with each other from the outset.
Well, it's like any breakdown in relationships, isn't it? It comes down to communication. And would you agree that that communication should be both verbal and in writing?
Yes, verbal and in writing, because I appreciate in the real world, a lot of sort of discussions and negotiations and things on site happen entirely verbally. But I cannot encourage people enough to follow things up in writing, because ultimately it goes back to one of the biggest things we preach to people is the importance of records. If you find yourselves in a construction dispute, it doesn't matter if you're right or wrong. Often the party that's got the better records and can prove what was said on what date, they're the ones that are probably going to win that argument. So if there are a lot of sort of verbal agreements and text messages and things like that, keep hold of copies of text messages, things that can support your argument. But if there's entirely sort of oral agreements, just follow it up with an email that evening. We met on site today. As discussed, we're going to go off and do X, Y, Z. And at least that way, if the worst case happens and you fall out with somebody, you can back it up at a later date.
Absolutely.
To support your argument.
Yeah, you've got the paper trail, haven't you? I mean, it's the same in terms of employment. This also, it's exactly the same as I'm sure you know in an employment tribunal. It's not so much whether it's you're right or wrong. It's what's your process and have you followed it, and how can you prove that you followed it? It's that due diligence, and yeah, I think it's a combination of not hiding behind email, but not just having a conversation verbally, having the paper trail, so to speak, metaphorically, to back it up.
Yeah, exactly. And yeah, a lot of things, emails are impersonal. So yeah, I would encourage a lot of, site meetings, etc., to take place in person, but follow them up in one way or another, whether an email or meeting minutes is another one. Send out meeting minutes after the meeting. This is what we discussed. Just so that there is some sort of record.
Exactly. It doesn't have to be war and peace, does it? It's just following our meeting today. This is my understanding of what was discussed and agreed. If you've got anything to add or amend, please let me know. So we were talking there about common mistakes that companies make, and one of them is not having terms and conditions in place or a contract. One of them is perhaps burying their heads in the sand and just hoping it will get better. Is there anything else that you see that's quite common?
Yes, particularly for the sort of larger SMEs, the guys that have, maybe started out fairly recently, but all of a sudden find themselves working on bigger projects for sort of main contractors. And that's when you go from, maybe a bit of an informal contract or terms and conditions to, standard form construction contracts that have been issued by main contractors, like JCT and NEC contracts that we discussed earlier. And, they're the proper construction contracts, i.e. 100 pages long and reams of drawings and schedules. And if somebody is not aware of how they work and what to look out for in them and just signs them and agrees, oh yeah, we'll come and it'll be fine because everybody's friends at the start of a project. But if you just enter into sort of contracts with main contractors that have been doing this for sort of 20, 30 years and know what they're doing and know how to pass risk down the way to sort of the subbies they're engaging, you can soon come massively undone by biting off sort of more than you can chew. And if you don't have any sort of experience with these type of contracts, don't just sign up to them and hope for the best, which is unfortunately what a lot of people do. it is well worth going to either attend CPDs by law firms. A lot of law firms, Quigg Golden, other law firms that do construction law, they'll do free sort of hour-long webinars and teach you the basics on JCT contracts or NEC contracts. You can do longer courses on them. You know, we offer a 3-month, I think it is, course on NEC projects, contracts. You can watch every Thursday night and learn about NEC contracts and just learn what you're dealing with when you sort of make that jump up to the larger projects with those contracts. Don't just hope for the best is the shortest bit of advice I can give.
Would it also be advisable just to have pay somebody just to oversee, to have a look through the contract and make sure that, there's nothing there? Because, you know, with the best will in the world, they're never going to be as proficient as a qualified solicitor, are they? And it's good that you have some kind of background knowledge in the same way that I do in lots of different areas. But I always say, look, I'm not an accountant, I'm not a lawyer, go and check it. But these are my thoughts and these are some questions to ask.
Yeah, definitely. We offer, which I presume most construction sort of law firms will offer, we review a lot of contracts for people at the onset of a project, and we go through as a kind of traffic light system where we identify the clauses that are of concern. Obviously, green, okay, fine, just be aware. Amber is kind of, it's a bit, you know, it's a bit of a commercial decision for you guys. And red clauses are kind of, look, if you're taking this on, you should be negotiating it in some way or putting additional money into the project to sort of cover the risk. It could be, you know, taking risk for designs prepared by the client or taking risk for site conditions, all sorts of things. And we do a lot of those contract reviews. They're relatively inexpensive, you know, £1,000 to review the whole contract for you and produce the document setting out the risks, which if I find things that are potentially very onerous for you, that's money well spent, because, you know, a year, 2 years down the line, if we hadn't have found that and the project had been delayed, and you were barred from bringing claims for delay, say, unless you'd notified within set timeframes, that could end up costing you way more than a £1,000 outlay at the beginning of the project. So yeah, I'd recommend being proactive rather than reactive when it comes to sort of contracts.
Absolutely. So get your house in order, make sure you've got the written documentation, don't bury your head in the sand, communicate, and seek advice where appropriate. If things do go sour, when is the right time to involve a solicitor?
I would often say involve somebody sooner rather than later, purely because the other side to the dispute, the other party you're in a dispute with, they don't need to know that we're here. We can advise you in the background, because if we become straight on record straight away, yes, it can sort of get people's backs up. It can make them a bit suspicious, but often I'll advise people in the background. You know, I'll even write letters on their behalf that they'll send from their company letterhead rather than from me. So it covers all the bases, but it doesn't look like it's come from a lawyer. It looks like it's come from them. And the other reason to involve us straight away is a good solicitor, in my opinion, won't just tell you to jump straight into sort of dispute resolution. You know, they won't encourage you to jump straight into issuing court proceedings or commencing an adjudication. You know, our role is to do what's best for the client, and often what is best for the client is finding an amicable solution without spending tens of thousands of pounds on lawyers, because if it ends up in front of a judge, the only people really that win are the lawyers, because we're getting paid a lot of money. So we will encourage people, you know, get round the table, do a deal. A good deal often means both parties walking away feeling equally unhappy. But ultimately, that's better than shoveling money into some kind of formal dispute resolution procedure. So yeah, I would encourage, go see someone straight away. We offer initial sort of 1 hour consultations for free for clients. Come in, speak to us. We'll brief you, talk it through with you. You're not going to, get a bill for £1,000 just for coming in and speaking with us. And I'm fairly certain a lot of law firms offer sort of similar things. So to use it to your advantage, go and see someone and just get their initial thoughts on it. And if you can't resolve it, then you can go back to them and be like, look, I tried.
Yeah.
Now what?
Yeah. So when a customer relationship starts to break down, you're saying act fairly soon, get legal advice. You offer a free 1-hour consultation. You offer the service of writing letters on their behalf without it looking like it's come from a solicitor. Any other advice at that stage?
I would recommend, I know it's difficult, particularly for sort of business owners, but you need to try and not let things become personal. That is a massive issue. If two parties get themselves buried in and it becomes like a personal, almost vendetta between them, that's only going to end up one way, and that's going to be informal dispute resolution. You need to try and keep level-headed and take a commercial view on a matter rather than kind of a personal approach to it. If you feel someone owes you £10,000-20,000, they may well do, but often it's going to cost you a lot more if you end up in sort of formal legal proceedings to try and recover that amount of money. So you're better off trying to keep it professional and find an amicable resolution without, jumping straight in and becoming entrenched in, a formal dispute with the other party.
And presumably face-to-face communication as well.
Yeah. Emails, emails can be misinterpreted. You can use the wrong sort of word, and one party reads it one way, one reads it another. Face-to-face is definitely the best way to resolve disputes. And that goes back to, keeping it relatively amicable. If you get to the point where you can't even be in the same room together, that's not ideal. That's not great. And maybe then that's when you need to get sort of advisors and legal advisors involved who can act as the sort of go-between. But ideally, you can sort it out yourselves in a room together. Yeah.
Some really good advice there, James. And we've touched on it briefly around the training that you provide. Do you want to just talk to me to finish off a little bit about that? Say, a builder in that bracket, 250K to 3 million. What would be some good training that you would recommend that they could go on?
I would, if I was a SME builder at that sort of turnover, I would be going on to the professional institutions websites, like the Chartered Institute of Building. They offer a lot of good sort of webinars that you can watch, often for free. They also put a lot of seminars on for members, and non-members can attend, but you have to pay. I'd be going on to law firms that do construction law. If you just literally type in construction law into Google, you'll find, 10, 15 of them throughout the country. And often on their websites, I know we do on ours, they'll be advertising webinars on a variety of sort of legal issues. And you can find them, every week, every month, however often you've got spare, and watch webinars by lawyers that are a way of learning for free, basically. If there's anything that you're not unsure of, if you've been offered a project but there's a JCT contract, I guarantee you'll be able to find a webinar on the basics of JCT. If you get offered a project on an NEC contract, you'll be able to find lots of webinars on NEC contracts. It's about going out there and being proactive, basically, and having a look around and doing as much learning as possible. The legal side of things is often something that people don't want to talk about because it's a bit scary and you think it's going to be very hard to understand. But there are lots of ways of learning the basics to a sufficient level to cover your backside, so you know what you're doing and what you're looking out for.
And Quigg Golden provide that training. Is that in online and physical workshops as well?
Yeah, we do a bit of both. We put on a lot of sort of lunch and learn webinars on weekdays, normally sort of 12, 1 o'clock-ish. We do them throughout the 3 offices. So some are aimed at the Republic of Ireland, where we've got a Dublin office. We do some out of our Belfast office, which is aimed at Northern Ireland, which the law kind of overlaps with English law because it's part of the UK. And then we also do them here in the Maidstone and London offices. We do face-to-face sort of webinars as well, often in the evenings, seminars, often in the evenings. They happen maybe once every couple of months out of each of the offices. So look out for them. You can go along if you're based in either Dublin, Belfast or the Maidstone sort of region. You can go along to those. And we cover a variety of topics for an hour or two. And it's basically a chance for the attendees to get free legal advice because we stay around at the end to answer questions. You know, You can ask qualified solicitors for advice for free. They're a great way of learning and sort of taking the initiative and going out there and taking efforts to sort of broaden your understanding of construction law.
Fantastic. And just finally, anybody that's listening that wants to find out more about Quigg Golden, where is the best place for them to go?
You can follow me on LinkedIn, James Sargeant at Quigg Golden. If you search me, you'll find me. We also have a website. If you search for Quigg Golden on Google, we will come up. And there's lots of links on our website to articles and all sorts of things that we write as lawyers and publish. And they're probably the best place to look us up.
Fantastic. Great. Well, it's been lovely chatting to you, James, and you've provided some really sensible, useful advice there. And so thank you very much for your time.
Pleasure. Thank you for having me.
I really hope you have enjoyed today's podcast. I would love to invite you to join our Trades and Builders Business Growth Group on Facebook, where I regularly share lots of information to help you create a more successful trades business. You can also order a copy of my book, Build and Grow, which is available on Amazon.